Hi, my name is Marcus Wabshall. I'm an immigration attorney and the founding attorney of Veritas Immigration Law located in Southwest Florida. And today I want to talk about how to get a fiance visa. So there is a special type of visa available specifically for fiancés of U.S. citizens who are currently living outside the United States but who want to come into the United States in order to get married to their U.S. citizen fiance. So before I jump into some of the details, I just want to make really clear who is eligible for this type of visa. Like, who does this apply to? So there has to be a specific relationship in place between a foreign national fiance and the petitioner must be a U.S. citizen, okay? Sometimes people get confused and they think that they can be engaged to a permanent resident and apply for the fiance visa, but that's not correct. The petitioner has to be a U.S. citizen. So if you're in a situation where you are engaged to a permanent resident, you are going to have to look into whether or not that person is eligible for naturalization, first of all, or maybe look into some other type of procedure for getting married and getting your residency some other way. But as far as the fiance visa goes, the petitioner is required to be a U.S. citizen, okay? So I just want to make that clear up front because sometimes people get confused about that. The fiance visa is also not going to apply to you if you are already married, okay? So that might seem obvious, but sometimes people are actually already legally married, but because they haven't had their wedding ceremony or the religious ceremony part of it, they feel like in their mind, they're not married yet, but legally they are. So if you're in that situation, you're also not going to be eligible for the fiance visa, again, because that the fiance relationship is no longer there, because in the eyes of immigration, you are already married, okay? A third example of somebody who's not eligible for the fiance visa would be if the fiance, the foreign national fiance, is already inside the United States, okay? So the purpose of the fiance visa is to bring the foreign national fiance who's currently living abroad into the United States in order to get married to the U.S. citizen here. So if the fiance is already here, then the fiance visa really doesn't apply. There's really no point to getting the fiance visa, okay? And the last situation I want to mention is for people who are engaged but who are planning to get married outside of the United States. If you are planning some kind of destination wedding or you're getting married somewhere that's not inside the United States, then the fiance visa is not going to be the process that you want to go through. Again, because the whole purpose of the fiance visa is to grant the foreign national fiance permission to come into the United States to do the wedding here, okay? So they can adjust their status while they're inside the United States. Okay, so those are just a few situations that I've encountered that I just wanted to, hopefully that helps clarify the specific type of person who is eligible for this type of visa. And if you have a situation and you're not sure and you have a question, you're always welcome to reach out to me and I can help clarify your situation. So the next thing I want to talk about are the specific legal and statutory requirements for actually getting the visa. So the first thing that I've already kind of talked about is the petitioner has to be a U.S. citizen and the fiance has to be living currently outside of the United States. So those are kind of like the two like big qualifications. A third qualification that you need to meet is you need to be able to show that you're free to marry legally. So this can pop up in a variety of ways, but typically what happens is somebody will have had a previous marriage and they got divorced, or the marriage was annulled, or lots of situations can come up, but usually it's just a divorce. So basically all that you need to be able to do in that situation is you need to present as part of your petition some kind of official document or certificate from the place where you got married, showing that like a divorce certificate or an annulment certificate, some kind of official document showing that you were married but you got divorced, or you were married and you got an annulment and now you're free to marry. Okay, so sometimes this can get a little bit complicated if there was a marriage that took place in another country, because there are the Department of State has special rules about reciprocity of certain types of documents that they will accept as proof of freedom to marry or as proof of a divorce. There are certain countries where there's a lot of fraud that happens with these types of documents. And so if you're in this kind of a situation where you're not sure what type of document you need or how to get that official document of a divorce or an annulment or something like that, then you probably want to reach out to me, because there are some special rules and some special obstacles that you can encounter in terms of getting these documents. Okay, so that's the third requirement. It's called freedom to marry. The fourth requirement that you need to be able to show is what's called the 90-day rule. And the 90-day rule says that once the fiance has been issued the Fiance Visa, from the moment that they're admitted into the United States, they have 90 days to marry the US citizen. Okay, so maybe that sounded a little bit confusing, so let me say it again. So after you get your visa accepted and approved, on the day that you arrive in the United States and you're admitted into the United States, from that date, you have 90 days to get married to your US citizen fiance. Okay? If you, for whatever reason, can't get married in those 90 days, or something happens, then that's something that we can talk about. I would encourage you to reach out to us and we can help figure out what's going on with that. But because you only have 90 days, you're going to need to be, you might need to be a little bit flexible with the timing of your wedding. So because we don't know necessarily when the Department of State is going to issue the visa or schedule the interview. So the 90-day rule can kind of potentially cause some problems with the timing of the wedding. So that's something you just need to be aware of ahead of time when you're planning. Now, the last requirement for the fiance visa is what's called the 2-year rule. And this rule states that when you file your petition, you need to be able to demonstrate that from the day that you filed the petition, you have to look back 2 years and be able to prove that you've met in person at least one time. So if you are, hopefully if you are getting married, this won't be a problem, but it is a requirement as part of the application. One of the reasons why is because the immigration officials just want to make sure that they're really concerned about fraudulent applications and fraudulent marriages. So they impose this 2-year requirement. Okay, so all you need to do is, as part of your application package, probably submit some pictures, some videos, some social media posts, maybe some letters from family and friends, just to demonstrate that you have met in person at least once within the 2 years preceding the filing of the petition. Okay, so those are the requirements from a legal standpoint to apply for the Fiance Visa. So now I want to switch gears a little bit and talk about the actual procedure for applying. So the process gets initiated by the U.S. citizen fiance who files a special form called an I-129F, petition for alien fiance. That petition does not grant any immigration status to the fiance. It just establishes between the immigration officials and you guys that there's a relationship. So there's certain types of evidence and certain types of information that they're going to ask for that you need to supply in a form of a package to prove to them that you have a legitimate bona fide relationship. Okay, so it's really important that you put together the best package possible because you don't want immigration to be scrupulous of the relationship. And this is where hiring an attorney can really help, because if in the process of compiling evidence to prove your relationship, you forget something or you miss something or you overlook something, the immigration officials, they won't necessarily deny the application, but they will issue you a request for more evidence. And that just delays the process significantly and can cause a major headache for you. So it's a really good idea if you can at least hire a lawyer for this part of the process to make sure that you have a really thorough package put together so that there are no delays or requests for additional evidence. So that's the I-129F. Once the I-129 gets approved, the immigration officials will send it to the National Visa Center, who will do another review to make sure that they're satisfied with all the evidence, all the documents, and that all the fees are paid. Once the National Visa Center is satisfied, they will send the case to the embassy in the country where the foreign national fiance lives. And they will schedule the interview and let the fiance know about any medical appointments they need to make, and the interview and any documents that they need to bring to the interview with them. So during the interview, it's really important to be organized with your story, because you're likely going to get asked some detailed questions about the nature of the relationship, how did you meet, and those types of things. So you really want to have your story organized to legitimize your relationship and to persuade the officer that this is a bona fide, good faith relationship. Okay, so they just want to make sure that this is true love. They want to make sure that this is a relationship that is going to be long-term and legitimate. So if they're not convinced about that, even though it might be a real relationship, if the officer isn't persuaded, then you run the risk of having your visa denied. Okay, so it's really important to be organized and articulate about your story. Now, assuming that the consular officer approves the visa after the interview, they will issue you the visa, and then you will be free to make your plans to travel to the United States, where you will present yourself at the port of entry, and the last immigration official that you will encounter is a Customs and Border Patrol agent who will have basically the last say regarding admitting you into the United States on your fiance visa. So, and then from that point, you have 90 days to get married and then to adjust your status. So the process is, it's not extremely difficult, but it does require some organization and some very intentional gathering of evidence and information leading up to the interview and with the filing of the I-129. So in terms of timeline and of the process, I can't be certain, but because it depends on which service center your application is sent to. But generally, I would say that this process could take anywhere between 6 to 12 months to process the I-129 and have the case sent to the embassy. So I would be looking kind of around that time frame. If you have questions about getting a fiance visa or any other immigration related matter, you are more than welcome to reach out to us for free. We will evaluate your situation and your case and help you to make the best decision possible. Please visit our website, veritasimmigrationlaw.com. Visit our Facebook to get more information or to make an appointment. Or you are always welcome to give us a call at 305-306-7833. Thank you and have a great day.